Since Donald Trump put not one, not two, but three new justices on the Supreme Court, right-wing politicians and organizations have been challenging abortion rights at the state level in an effort to get the court's new conservative majority to chip away at the constitutional protections established nearly 50 years ago in the landmark case of Roe v. Wade. And soon those efforts will be put to the test. Yesterday, as I'm sure you know, the judges decided to take up a case about a new Mississippi law that looks to ban most abortions after 15 weeks of pregnancy, 2 months earlier than current legal limit. And the White House had this response.
Over the last 4 years, critical rights, like the right to health care, the right to choose, have been under withering and extreme attack, including through draconian state laws. And the president and the vice president are devoted to ensuring that every American has access to health care, including reproductive health care.
So how likely is the Supreme Court to strike down, or more likely, greatly narrow the protections of Roe v. Wade? And what happens if they do? I'm joined by Suffolk University law professor and constitutional law expert Renee Landers, who's on the Planned Parenthood League of Massachusetts Board of Directors. Renee, it's good to see you as always.
It's great to see you too, Jim.
Can you do 30 seconds on what rights Roe v. Wade established in this country?
Sure, Jim. So Roe v. Wade, decided in 1973, was a case that ruled that a woman and her doctor could decide to terminate a pregnancy. It established kind of a sliding scale on the trimester, what's known as the trimester framework. Within the first trimester of pregnancy, a woman and her doctor could decide to terminate the pregnancy with very little interference from the state. The second trimester, the state was allowed to impose regulation for the protection of the health and safety of the woman. And then in the third trimester, more extensive regulation was allowed, but up to and including prohibiting abortion entirely.
How would the Mississippi case change that?
Well, the Mississippi case, so after Roe v. Wade, there was another case in 1996 called Casey against Planned Parenthood, Planned Parenthood of Southeastern Pennsylvania. And in the Casey case, the court changed to a different standard. It sort of reformulated from the trimester standard to the viability standard. So the Casey court said that the abortion could not be prohibited before viability. Fetal viability. And fetal viability is somewhere around, this is an imprecise measure, but around 23 to 24 weeks. And the Mississippi law at issue in the case for which the Supreme Court just granted cert specifies that abortion would be prohibited in most circumstances after 15 weeks.
So even though I wasn't paying much attention in my constitutional law class in law school, I did hear something about precedent. And I did hear Chief Justice Roberts in his confirmation hearing talk about established law in this country. 47 years, this has been the law of the land. How much does that mean to the 6 conservative-leaning members of the court?
Well, I think it means a lot to Chief Justice Roberts. And we saw evidence of that in the June medical case that the court decided last term, where the court was presented with a law that was almost identical to a law that the court had struck down, a Texas law that the court had struck down in an earlier case. And even though Chief Justice Roberts had dissented in the earlier case, which it had invalidated certain restrictions on abortions, he voted with the majority in June medical because of the impact of precedent. So I think that he values it very much. I'm not sure how much we know about some of the other justices, the newer ones that former President Trump appointed, for example.
So I hate to put you on the spot, but why not? What's the worst and best case scenario in your estimation come whenever this decision is released? Obviously no oral argument yet, in June of next year.
Right. So I would say the worst case scenario is that they take the invitation and totally jettison the Roe v. Wade, and decide that there is actually no right in the Constitution for a woman to terminate her pregnancy. That's the worst case scenario. I think the best case scenario that we can hope for is that the court does what it did in last term in June Medical and say, that it doesn't want to, alter the precedent and therefore might invalidate the 15-week the ban on abortions after 15 weeks because of the viability standard established in Casey.
I think I asked the wrong question. What was best and worst? I think I should have asked you, what's the likely scenario? Because I have a feeling that neither is.
Yeah, I think the likeliest scenario, or well, I'm not sure if it's the likeliest, but a third possibility is that the court, part of this chipping away at the right to abortion would be that the court would say, well, 15 weeks, most abortions that occur in the United States, 90% or more occur before 13 weeks of pregnancy or around that time, and that this would not prohibit so many abortions, and therefore, it would change the viability standard, but it would uphold the law, but not outlaw abortion in the early stages completely.
We should also mention the states have a say here. I don't want to leave people with a wrong impression, even if the worst case scenario comes out of the Supreme Court. Just a few charts. Here's a list of U.S. states that have laws protecting abortions if Roe were to be overturned. It includes, obviously, of local interest, Connecticut and Rhode Island. Next is a map of states that have constitutional protections of abortion, even if Roe was overturned. That includes Massachusetts. But on the flip side, there are states with trigger laws, about 10 of them, give or take a little, which, if Roe v. Wade were to be overturned, automatically whatever protections they had in place would be repealed. So essentially, in the worst case scenario in terms of the Supreme Court, Renee, what would matter is what state you live in or what state you have the resources to travel to. There'd just be unequal justice around the country. I don't mean just, but there would be unequal justice, unequal access to abortion around the country.
That's correct. So I just wanted to offer one slight modification to your charts because
Sure.
Massachusetts has some new statutory protections that were just adopted,
That's right.
this year for, anticipating this very scenario. But yes, I think you're absolutely right that abortion access is actually not equal right now because in Mississippi, for example, there's one abortion clinic that continues to function, which is the litigant in this particular case. And around the country, the situation is quite dire in many states for access to abortion. Women have to travel long distances to obtain an abortion.
Renee, before you go, Marjorie Egan and I have been on the radio for a couple of decades, and she's been saying forever that once a significant right is established by the Supreme Court, it is rare, if ever, that right is undone. Is there an example of a Supreme Court creating a right like they did in '73 with Roe v. Wade, which they have subsequently completely undone?
I can't think of one off the top of my head. I think that in the Casey case that I was mentioning earlier, which established this viability standard, Justice O'Connor, in her opinion in that case, developed a 4-part test that the court has sometimes been using when it's thinking about whether it should overturn a precedent. And, this is the kind of, the court decided in Casey. And I think that the conclusion they reached in Casey still obtained today, that there's no real reason why we should change that precedent. There's a substantial reliance interest that society has developed. If birth control fails, that abortion is a backstop. Sometimes abortion is necessary to protect the life and health of the woman. And also that the legal doctrine, the factual basis or underpinning of the case have not changed substantially. So according to the court's own criteria, there's really no basis for changing the precedent.
I hope they're listening to you. Thanks for the tutorial. Good to see you as always, Renee Landers.
Oh, always. Thank you for having me, Jim.